get your public inquiry?
It's a matter of trying to call on Canadians to step forward and put pressure on their governments. We think we're seeing pressure now on local Conservative MPs across the country around matters of the moral standing of this particular government. And we think adding to those pressures will result in what we want, which is the public inquiry.
And about, if I understand the judgment, the Conservative Party had to pay for everybody's expenses, right? At the end of the day, that's so. My question is, could they actually appeal that part of the judgment? Do you expect them to do
They
that?
have no right to appeal.
No, okay.
They have no right to appeal to the Supreme Court.
And about the money, so now does it cover everything? Like, because you were saying that people gave you money to undergo this. Now you've done it, but then you're getting money back from the Conservative Party. What happens to the money?
Yeah, Stephen, I think, should talk to this question of costs.
Well, Gary can comment on the fundraising activity of the council. What the judge decided was that the respondent MPs would pay our costs on the motions. They brought 4 successive motions to prevent the issue from being adjudicated by the court, right? There was a motion to dismiss the applications as being frivolous and vexatious. There was another one that would have required us to deposit more than $250,000 in court as security for costs. They challenged the bona fides of the applicants with an application for champerty and maintenance, and finally they assailed Frank Graves' integrity. And the judge found, with respect to all of those motions, that they were brought for the simple purpose of delaying the proceedings and preventing them from taking their normal course, and ordered the Conservative MPs to pay our costs on a solicitor and client basis. So all of the costs associated with those motions will now be paid by the respondents. He also ordered the applicants to pay costs to the respondent MPs on the applications themselves, which he said would be modest. His inclination was to order modest costs against the applicants. So we have yet to learn what that amount would be. And so where this ends up at the end of the day, I mean, Gary can comment on how successful the fundraising activities have been, but we haven't yet gotten to the last word on you know, the question of costs and who will be paying them and in what amount.
At the end of the day, the end of our fiscal year is June 30th. Stephen and I have to sit down and figure all this out by June the 30th. But then our documents, our accounts are public information, so it'll be in there. I believe we are at $438,000 that has been raised. This is on the front page of our website. $438,000 that's been raised from individual Canadians to support the campaign. And we've had legal bills, again heavily discounted, of roughly $538,000. There'll clearly be a little bit more. So that's where we are in terms of our fundraising efforts.
Laura Bond-Stubbing, the iPolitics.
Yeah, just sort of jumping off of a question about fundraising. If you were to continue on with an appeal to the Supreme Court, what would be the cost of that, and did that have any factor in deciding not to?
The decision about an appeal was made by the applicants with their lawyer, and they considered a number of factors, and I wasn't there when they considered those factors.
So the cost was not considered?
I don't know if it was or not. We were convinced that if we had appealed to the Supreme Court that Canadians would have stepped up and we would have raised sufficient funds to pay for that appeal. Because, you know, yes, an appeal to the Supreme Court is a complex legal process, but the bulk of the work has been done in the preliminary stages up through the federal court decision. I mean, that's where the bulk of the legal expenses are incurred.
Hélène Buzetti, Le Devoir.
I recall when you first announced this legal initiative that you mentioned quite clearly that the purpose was not to identify the perpetrator of the calls, but rather to prove that calls had been taking place, and therefore that the elections have to be canceled. So I'm just wondering, so I guess it's not a surprise that the ruling does not identify a responsible person. So I'm just wondering if there could be another kind of legal procedure that you could undertake, which would have as its main purpose to identify the perpetrator of those calls. Is that a legal possibility?
We are exploring all possibilities at the moment, and we hope to be in position in the not-too-distant future where we can announce other initiatives.
That's it.
You know, Justice Mosley, you should read his decision carefully on this question. He said the most likely source of the data used was Sims. He found that the respondent MPs were not involved, but he said he made no finding of whether or not the Conservative Party of Canada was or was not involved. So he did not exonerate them. He made no finding with respect to the Conservative Party of Canada.
Well, therefore, my question, is there another legal venue you could use to try to find out if there were indeed involved?
I don't know if you want to answer any further.
I mean, Gary's pointed out that the public inquiry would obviously be the best and most effective way to get at that. And if the government is disinclined to call a public inquiry, and you might wonder whether it would or it wouldn't, then, you know, as Gary's indicated, that he's asked me to consider whether there are alternatives. And we'll wait and see what the government does.
Suzanne Delacour, Toronto Star.
Is there do you have a ballpark figure of what the Conservatives could be forced to pay by way of costs?
No, not yet.
$10,000 or $100,000? Do you know?
Somewhere in between those two figures.
And the judge, Justice Mosley, has asked for representations on the question of the modest costs that he's contemplating with respect to the respondent MPs. So we have to wait for that process to play out.
There already is a large investigation going on into robocalls in the last election, and it's run by the Elections Canada Commissioner. Are you, A, worried about getting in the way of that, because that's been having some trouble already, and two, are there options then that you could consider that would help Elections Canada?
Elections Canada has made it very clear that they've been stonewalled by the Conservative Party of Canada and various Conservative Party officials in trying to investigate what happened in May 2011. They cannot compel evidence. They cannot compel testimony under oath. And they're looking at this through a different lens than we are. They are looking at whether there was criminal behavior, and if there was, their job is to prosecute that criminal behavior if someone contravened the act. We're looking at finding out what happened, which is a different issue. So I don't think you're going to see that through Elections Canada. What would help Elections Canada, and what we're calling for as well, is to give them the authority that they've recommended that they be given, additional authority, additional responsibility, require all of the companies involved in voter identification calls and get out the vote calls to register with Elections Canada, require them to maintain records, require them to release those records on request to the Commissioner of Elections. So that's where Elections Canada is. We will not get in their way, I mean, because their process is underway. What they're attempting to do is to find out whether there was criminal behavior and prosecute the individuals involved in that.
Christy Kirkup, Sun News.
Just in terms of accessing Sims, you know, is there the suggestion that perhaps that the access could have been easier? It could have been easier than perhaps, you know, certain people have indicated that it was tightly controlled. Is it actually tightly controlled, the data?
We have no idea. I have no access to their database, and I have no idea how tightly controlled how tightly managed and tightly controlled it is, but I would assume that they have, leading edge security systems in place because it's a very important database. In the riding we know that people in ridings have certain access to the database, but it's only those parts of the database that relate to their ridings. And my assumption is that they've got their security systems in place so that anyone who has access to the national database would have to be, part of that very inner circle. I think that's why the Conservatives are worried about this matter, because they know who did it, and they won't come forward.
I wanted to ask you, in the case of Michael Sona, for example,
Yeah.
the Conservatives have focused a lot of attention on
Yes.
one individual in particular. What do you think about that tactic, and do you think perhaps it's been tunnel vision on one individual?
Listen, we understand that, yes, Michael Sona has been charged. I have difficulty believing that he would have had access to the national database. I have no idea whether he had access to the database that related to the riding of Guelph or not. He claims he did not. And that's another process through which we may be able to identify who was involved, because I understand that his lawyer will be subpoenaing people to appear in that case. And the objective would be to try to prove or try to reveal who has access to the central party database and on what parts of that database they have access.
I would just, I think if you take a look at paragraphs 183 and 184 of the decision, in 183, Justice Mosley is reciting the views of an expert. His name is Robert Penner. And Mr. Penner's evidence is that access to the party central database is carefully controlled, and that the calls at issue in this proceeding would most likely have been organized by a person or persons with access to a central information system of a political party, in this case SIMS, the financial resources to contract voice and automatic service providers. So we know from Guelph that it's very cheap to hire robocalls. It's expensive to hire voice calls. And in our case, and as the judge found, there were both live calls and automated calls. And finally, that this individual would have the authority to make the decisions that were engaged by rolling out a campaign of this scale. And in the very next paragraph, the judge says he finds that Mr. Penner's evidence was helpful and consistent with the evidence as a whole, that there was an orchestrated effort to suppress the vote during the 2011 election, I'm quoting, by a person or persons with access to the SIMS database. So there you have the judicial findings of how this was carried out, accepting the views of an expert who actually provides these services to another political party, and said, well, this is how it would have happened. It wouldn't have been serendipitous. It wouldn't have been various people having the same idea across the country. This had to be something that was organized at the center.
Ma liste est vide. Y a-t-il d'autres questions? Non. Merci à vous trois.